Hello, and welcome to another episode of the Asian Seller Podcast. I'm your host, Meghla Bhardwaj, and today I'm joined by Yael Cabilly, who is a U.S. attorney and she's based in Israel. Hi, Yael. How are you doing?
Hi, I'm great. How are you?
I'm doing well. Thank you so much for joining us, Yael. And we've known each other for quite a while, and I've been seeing you speak at different conferences and at different webinars. So it's really good that we finally got to connect and talk over here. So we're going to be talking about trademarks and patents on today's episode. And there are quite a few important issues that you're going to be talking about that are very relevant, especially now because we're into Q4 and sellers are going to have a lot of issues with suspensions and complaints and other things. So I think it's a very timely topic as well. So before we go into the topic, Yael, do you want to do an introduction and tell us about yourself, your background, and how do you help Amazon sellers?
Yeah, of course. So I'm originally a trademark lawyer. I've been doing trademarks for 15 years. In 2015, end of 15, I started working with Amazon sellers. So first on intellectual property issues, trademarks, copyrights, and then on suspensions. And then I decided to start a firm that does only IP and e-commerce law because I saw there were almost no lawyers in that field. Today we're 11. We do, I think 98% of my business is Amazon. We do like half of the firm does suspensions and problems on Amazon, and the second half of the firm handles trademark, copyright, patent registration, and enforcement. Yeah, we have about 4,000 sellers, clients over the world, mainly in the US, but also in other countries, Israel, UK, China, some of them in India, some of them in Singapore as well. Very few, although. Australia, yeah.
Awesome. That sounds fantastic. Okay, so let's talk about trademarks. And let's say I'm a new seller and I am starting to sell on Amazon. And how do I do this right? I want to, of course, get my own brand trademark and registered and everything. But what is the right process of going through the entire, what's the right way to do the entire process?
Yeah, I mean, today, if you're a private label, it's very difficult to operate without a trademark. So today, most of the private labels know they need a trademark. Without it, they won't get the brand registry. Without it, they cannot remove hijackers. So they do start the process. The best way to do it is to first conduct a search to make sure that the trademark is available, and do the search. That's very, very important. Do the search before you manufacture. At the beginning, when you choose the name, at that point you should do the search. And the reason for that is that we cannot change the trademark later. So if, for example, and we have a lot of cases like that, if you choose a name, you manufacture, you start selling on Amazon, you start getting reviews, then you come to us, you want a trademark. We do a search and we tell you, sorry, we cannot register the trademark because it's already taken. Today, you cannot just change the brand to another brand and keep your listings with the reviews and everything. What you have to do is actually to start a new listing, a separate listing, and do everything all over again. So I really advise sellers, most of the lawyers actually include the search in the registration cost. So for example, if you come to us before, when you manufacture, before the registration at the beginning, we do the search, and then those $180 is then retracted from the registration cost. So it doesn't even cost you more. And then if the trademark is available, and you know that you can continue, manufacture, sell, and then go to an attorney and register your trademark. It's important to register the trademark in the specific country where you're selling. So if you're selling on Amazon.com, please don't register in the UK or Germany or some other countries where it may be cheaper, because when you'll have a hijacker, or when you have a counterfeiter, somebody using your trademark, you need a trademark in the specific country. Otherwise, Amazon doesn't do anything. So very important to do a search, and then you apply for a trademark. Most of the attorneys know what they're doing. I mean, today there's also the accelerator. So when we file through the accelerator, what happens is that instead of waiting 7 to 9 months to get the brand registry, you get it 2 weeks from the date you applied for it. So 2 weeks, within 2 weeks, you basically get the brand registry. Which allows you to use all the tools, the advertising tool, the EBC, A+ content, etc. But it doesn't allow you to remove counterfeiters because you don't have the registration yet. But at least you have the brand registry and you can use those tools. So I think it's very important for private labels. When you sell the business later, you really want to have a trademark. That's, I guess, the first thing that buyers are looking at. Do you have a trademark? Where's your trademark? Otherwise, they won't buy it.
Right. So when I'm looking for a brand name, a couple of things. So first of all, would you suggest that sellers should come up with a generic brand name that can be used across product categories? That's one question. And then how do they go about doing a search to find out if that brand name is already registered?
Yeah. So generic name, it depends what you mean. So if, for example, the name that you come up with is great phone covers, which is very generic, and you sell phone covers, then your trademark will be rejected because it's too generic. They will not give you monopoly over a word that everybody uses, right? I mean, if you're selling computers and you take over the trademark great computers, imagine all the other sellers of computers that will not be able to use that name. So the USPTO rejects, and all other countries, by the way, they reject generic and descriptive names. So, but you can use suggestive names like, I don't know, Logitech, for example. That's a suggestive name, right? It kind of suggests, but not that much. Apple is not at all descriptive. It's a great name because you don't sell Apple. If you're selling apples, then that's a descriptive name. But if you're selling computers or phones, then that's an amazing name. So I think for sellers, the best is to use a name that, I think you meant, when you're saying generic, you meant that it doesn't relate to one specific product, right?
Yes,
That's what you said.
that's what I meant.
So you won't have to register every second a new trademark. So that makes sense. So if you register the trademark.
Beautiful butterflies. I mean, I'm just making it up and it's a bad name and it won't probably but something generic like that, like beautiful something, or that can be used across.
Red butterflies. Okay. Red butterflies could be a great trademark for anything. So that's good because you have the trademark, you have the brand registry, you can use it for other products. So if, for example, you used it for bottles and then later you want to sell, I don't know, a phone cover, although it's a different category, the brand registry will remain. So you have the brand registry here, you have it here there. You do want to register it in the second category later so that you'll be protected against, people jumping on your listing. So again, while you'll have the brand registry, they don't care about the category when it comes to brand registry. When it comes to infringement, they do look at it. So they want to see that you have a trademark in the specific category for the specific name. So if, for example, you've registered red butterflies for bottles, okay, and it's registered, you get the registration, you finished, you have a listing, then you open a new one for phone covers, then you'll have the brand registry for the phone covers, and you'll have to apply for another trademark, red butterflies, in the category of phone covers. And once you finish that registration, you can also enforce that second listing and remove hijackers. So that's how it works. But it does make sense to use the same name so that you'll always have the brand registry.
Right. Makes sense.
And how do you do a search?
How do you do a search? And can you do a search yourself, or is it always better to go via an attorney to do a search?
It's a good question because, at the end, it doesn't sound, whatever I'll say sounds bad because I'm an attorney, but I think that, you know, most of our clients don't do a proper search because they usually look for the name. For example, if your trademark is tenor, okay, then most of the sellers would just look for tenor, right? And that's it. Although the law talks about likelihood of confusion. So if there's someone, if you're selling microphones under tenor, and there's someone registered for a microphone for tenora, okay, it's confusingly similar. Now, most of our clients, and I understand why they're not, you know, attorneys, they would only look for their name. So tenora, they would probably miss. And this is where they come to us later and they say, okay, I want a registration. And we're saying, sorry, there's tenora, it's super close to yours. You won't get a trademark. I'm not going to charge you to get a registration that will fail. So if you're doing a search, actually we can do one just quickly to show you how it's best to do it if you're doing it yourself. Basically, it's important to cover similar trademarks. So for example, let me just no.
Yeah, so for you guys listening, Yael is now going to share her screen, and we're going to do some searching over here.
Yeah,
You can also watch the video on YouTube if you want to take a look at the screens. Yeah, go ahead, Yael.
Right. So what I do is I go to uspto.gov. We're going to do it just a second to show you. I'm not going to teach you how to do searches, but if you go to uspto.gov and you press on trademark, then you press here on the search, okay? And you can choose the first search, which is a basic search. Now, if the trademark that I want is tenor, right? So I would search for tenor or tenora or tenoro, or you see what I mean? Like every possible, every possible combination, or tenor, etc., etc. We use more complex tools so that you won't have to think of crazy combinations. Here I would choose live so that I don't focus on dead trademarks are not important because they don't block you. So I choose live, and then I see all the tenor combination. I would continue. And then when you see the trademarks, you have to go ahead and, press on them and see what is the field. So if you're selling microphone and there's tenor for dinnerware, that doesn't concern me because it's in another category and there's no likelihood of confusion. Remember, likelihood of confusion is the test. So if I go back, let's see here, tenor, computer application software for mobile phone. Here it gets closer. It gets a little closer. So you should review and read everything. And then you go one by one, you have a lot of them to review and make sure there's nothing in your field, okay? And if you have something that's closed, then you can consult with the lawyer or just move on to the next name. So it's always good to do a search, by the way, to do it yourself even before you go to a lawyer, because sometimes you'll just kill the name yourself and you save the search. So maybe start with the search yourself, uspto.gov. And then move on to a professional search, or just take the risk and move on with your product.
Yeah. So is it just USPTO where they need to do a search, or is it also a good idea just to do a search on Google and see if there are other, companies out there, or it doesn't really matter? I mean, as long as the brand is not trademarked, it doesn't matter if it's already out there.
Actually, in the States, there are common law rights, which means that if I've been using the trademark tenor for 2 years, selling microphones in New York, even if I didn't register it, I have rights. So if you go ahead and register your trademark, you'll probably succeed, by the way. The examiners don't look outside of the USPTO. But then I can cancel your trademark, and I can even claim that you're infringing my trademark. So it's always a good idea. That's also something that, most of the sellers do that. They do search if there's a similar name on Google. So do a Google search, do a trademark search on the USPTO. If you're going to sell in Europe as well, then do a search on the European database, same way as I showed you. Just remember to look for similar names. That's the issue. That's where it's difficult.
Right. And I think, of course, the other things that you want to consider is whether or not a URL is available. I think you want to make sure that you have, a good URL for your brand, and social media handles and all of those things are important as well.
Yeah. Yeah.
Okay,
Although
so
URL,
yeah,
by the way, today it's not so much about the domain. If you're selling tenor, tenor microphones, and tenor.com is taken, it doesn't mean that you won't take the name.
yeah,
Sometimes
yeah,
you'll choose tenor microphones.com, right? Or
exactly.
tenor.microphone. I mean, today there are so many new extensions, so it's endless. At the end, it's about your advertising and pushing your website, less about the name of your domain name.
Yeah, totally agree. Okay, so what next? So now I've got I've decided on my brand name and I've done a search. So how do I go about registering it? And it's different for businesses based in the US and people outside of the US, right?
Yeah. So if you're a US resident, you could register the trademark yourself and do it on the USPTO. Again, it depends how savvy you are, and if you wanna, if you do it, then watch a lot of YouTubes of how to do it and how to properly classify it. I think most of the sellers, for them, it's important that it will go smoothly and that it will be filed correctly, so that they get their trademark as soon as possible, and they do it through lawyers anyway. For foreigners, it's not even possible. They cannot do it themselves, so they need a U.S. attorney. So unless you have experience with that, or I do have clients that like to learn, and they can watch videos for like 2-3 days and become very savvy about trademarks. And so unless you're that, then just give it to an attorney and have someone do it for you, I guess.
Right. And then what are some of the things that we need to have before we go ahead and register the brand? For example, do we need to have packaging that shows the brand name on it, or a website, or what are some of the things that we need to
Yeah.
have ready?
So for the USPTO, to get a registration, eventually you need to show use. So you actually provide a specimen of use. So what you do is we usually provide a screenshot of your Amazon page to show that you're actually using the trademark and selling goods under this trademark. Or we show your packaging. Packaging is not a must. I mean, I can use your listing, and that would be fine as long as you're actually selling. But to get a trademark, you need to sell. So it doesn't mean that you have to file it when you're already selling. You can file it at the beginning based on intent to use, and then later, after a few months, then you can just submit the declaration of use and say, okay, I started selling. Here's my specimen of use. You won't get your trademark until you use it. So there are some people who apply for it and then ask for extensions, and then 2 years later they submit the specimen of use, and then they get a trademark. But the U.S., by the way, is one of the only countries that's doing that. They don't want people to just hijack trademarks without using it. In other countries, you don't see that. In Europe, you can hijack whatever you want. Same in China. By the way, that's an important topic. I don't know if have you heard of people having their trademark hijacked in China?
Yes, a lot. Big companies. I
Yeah.
mean, not not just small brands. It happens to big
Yeah.
companies because in China they are first to file and
Yeah.
not first to use. Whereas in
Mm-hmm.
the US it depends on, yeah, the usage of the brand. But Yeah, China. And it's very tricky sometimes because suppliers will register your brand and then your products will not be allowed to leave the country, and customs can
Exactly.
actually stop your product. So yeah, it's yeah, a lot of
Exactly. It's a
bigger
huge problem.
buyers. Yeah, go ahead.
It's a huge problem that we've seen in the last 2 years. It starts with an innocent email that our client receives. Hi, we're a law firm in China. We noticed that somebody filed for your trademark. We can help you and file an opposition. Of course, they're suspected to work with that hijacker, right?
Yeah.
So we can help you, and then they come to us and we look at it, and obviously someone has indeed filed for a trademark. So what we do is usually we file an opposition. In most cases, we show that this hijacker has already hijacked tons of trademarks and is not acting in good faith, and that we had prior rights. And most cases are actually, we actually succeed, but it takes a few months. And in some cases, if you want to get it fast, then you would buy it from that hijacker, unfortunately. So, for example, I had a client who's in the process of a sale of the business, and that happened during the sale. So he had no choice but to buy the trademark from that guy, and it cost around 10K. So
Wow.
yeah. So you don't want to get there. So just go ahead and register a trademark in China to prevent that from happening. Very important if you manufacture in China. If somebody takes your trademark, as you just said, they can prevent you from taking the goods outside of China. So very important. That's very risky.
Exactly. And I think that the time to trademark in China is, as you start scaling, maybe
Yeah.
while you're just starting out, it's not necessary, but as you're scaling, I think you should do that. And it's not difficult to register a trademark in China. I mean, there are, attorneys, maybe do you offer services in China as well
Yeah,
to,
we have associates in China. We file
yeah,
through them. I
yeah,
think every firm has it today because it becomes very important. I absolutely agree 100%. When a seller starts, it's not the first place I would file, like focus on the US.
yeah,
By the way, hijackers focus on larger sellers. They don't focus on small sellers. So only once you
exactly.
succeed, they'll take your trademark. So yeah, in later stages, as you said, just start, keep it in mind. At the beginning, they have so many expenses, so that's not one of the first.
Right. Okay, so that was a good discussion about trademarks and brands and everything. So let's talk about copyrights. So, what exactly does copyright include, and how do you avoid infringements of copyright?
Yeah, there are a lot of I think this is the most common infringement that we see, with trademarks and copyrights are the most common. What you need to know basically about copyrights is that it includes text, photos, and graphic designs. Okay, text, photos, and graphic designs. So text and photos, think of a book, right? Everybody thinks when you think about the copyrights, you usually think about some paintings of someone, right? A painting, or you think about a book, right? So when I write a text, when I write a book, I have copyrights in that book, even without any registration of that text. Okay, so I wrote a book. You cannot just simply copy my book and use my paragraphs and wording, right? Same goes for photos. Even without a registration, remember that, even without a registration, if I took some photos and I put them on my listing, you cannot take them and use them on your listing because you would be infringing my copyrights. And if that happens, by the way, I can give you a link of how to do it very quickly. If that happens, I can file a complaint within 2 minutes, and remove your photos from your listing, and sometimes even remove your entire listing because you use my photos. So the very important thing to remember about copyrights is that you have the rights without a registration. You can register, that's a separate thing, but that's only to have like an evidence. But really the rights are there. So if I took a picture, if I wrote a book, if I wrote bullet points on my listing, these are mine. If you use them, I can remove your listing. And if my son has drawn some, some ugly picture, he's not that talented, he has copyright in that. So whatever you create, that's photos, graphic designs, or paintings, or things like that, these are all copyrights. If you have, for example, I have here, like, look at that bag. Showing a bag of my laptop. It has like a graphic design on it. This graphic design is protected. So you cannot use my graphic design with the same flowers, and just put it on your product, even if it's a different product. So that, I think that once you understand that, you want to infringe any copyrights. So just don't take photos from others, even your supplier. Sometimes the supplier tells you, these are my photos, you can use it. And then you use it. And then you get a complaint from someone, and turns out these are not his photos. These are photos of a prior client of his. So never use a photo from your supplier. Just use your own photos. The text, don't take like full sentences from your competitor. This is a great way to be removed. So just, take your own copywriter. There are amazing copywriters in our industry that can help you write your listing, but you can also do it yourself. Just don't use others. You can use a word here and get inspired, but not, entire sentences. Um, and the graphic design, super, super important. We see a lot of them, for example, people selling paper plates.
Mm-hmm.
They fall a lot. I mean, they use graphic designs on those plates that they find on the internet or on other people's listing. And they tell me, I searched and there were no copyrights, but there's no need to do any search. If you use the graphic design and it's the same, you're infringing. Very simple, very, very simple. And what's interesting is that the same goes for you. If you have a graphic design, and you design something, you own the copyright. So first of all, you can remove anybody that's using yours. And also, if you want, you can go ahead and register copyrights in the US. That gives you some kind of evidence that you own it. But it's necessary only if you're going to sue someone. When you sue someone in the US, when you file a lawsuit, you need that registration. It's required. But if you're not going to sue anybody and you're just filing complaints on Amazon, you don't need a registration. Very important and very easy, right? Just don't use it.
Right. So, how do you register a copyright and on what aspects? I mean, specifically related to Amazon. So, let's say I have images. Can I register a copyright for my images, and where do I do that? I mean, is that also with the
Yeah.
USPTO, or is
No.
there a separate organization for that? Because I
Yeah.
know
It's
for publications, there's a separate organization that where you go and file, right?
Yeah, it's the same one. It's called copyright.gov.
Okay.
It's not the USPTO. It's copyright.gov. It's a separate website where you do it. It costs like, the official fee, the governmental fee is like $55 per work. Actually, registration of photos, I think it's a kind of waste of money, because I mean, these are the photos, you have copyrights in them. You're probably not going to sue anybody for the photos. What's important maybe to register is, those that have actually designed something for their product. So as I said earlier, like the design on my bag, or the paper plates with amazing graphic designs, or anything that you've designed and that's special, that I would copyright. This I would copyright, only if it's selling well, and it's a good product, and and there are no problems with it. So you can go ahead. Again, maybe not one of the first expenses, but when your business becomes serious, and for buyers, by the way, I always go back to the end, to the exit part, because I have that separate company that deals with exit. But we see that a lot. The intellectual property is super important to buyers. When they look at it and they see, if you don't have a trademark in the US, it's a disaster. If your trademark was hijacked in China, it's a problem. And if you have patents, if you have copyrights, it's more, the multiples go up. So the value of your business go up. And it doesn't cost much to register those, and it's really an advantage, I think, for
Right.
those who know what they have in, yeah.
Yeah, absolutely. And also, if somebody has, for example, if they're developing a fabric or a fabric-based product, I think the patterns there, or maybe even if they're doing merch, right? Merch products like T-shirts or other things. Okay, just going back to trademarks, what is the approximate cost to register a trademark? Because I've heard different people give out different numbers. There was somebody recently who posted in a Facebook group that he was charged over $2,000 by a lawyer, and they had to like go back and forth and file. Maybe the lawyer filed in one category first, but then it wasn't available. They had to file another one, or I don't know what happened, but they had to go back and forth, and it cost like over $2,000. But typically, how much should it cost, and what are some of the
Yeah.
pitfalls to avoid?
It depends if it goes smoothly or not.
Okay.
If everything goes well, then most of the attorneys charge between 550 to 650 of service fees, and then there's the official fee that's 275. So usually it's not more than 1,000, right? In most cases. But what if you haven't done a search and you haven't asked your attorney to do a search? A lot of attorneys ask for, I've heard crazy numbers of attorneys asking for 1,500 for a search and things like that. So if and most of the sellers think they've done a great job searching their trademark, right? So they go ahead and they register that tenor trademark for microphone, and they apply for it. And then 3 months later, they get a rejection from the examiner saying that there's tenora, okay, in that same field, and it's rejected. So if you want to argue against the examiner's objection, for example, if you think it's not right because you're selling tenor microphones and they're selling tenora, I don't know, software for whatever, and for some reason the examiner thought that it's similar, then we usually write arguments that explain why the examiner is wrong and you should get the trademark. So that that can be a 10-page document with with legal cases and explanations. So this can go up to another 1,500. I think that you shouldn't get there. We have 96% of success rate, not because we're geniuses, because we do the search. And when I see the problem, I'll tell you in advance. So even if your lawyer didn't suggest that you do a search, do the search. Super, super important, because you also avoid those problems and extra costs and and trademarks that you didn't think about. If you do a search, this tenora would come up. So you would never get to the point where you're paying extra 1,500 for a 10-page document. You wouldn't file it in the first place. So very important. I think these are the ranges more or less. I've heard of more, but usually it's when things go wrong. And sometimes you can't blame the only the attorney, because some attorneys do suggest a search, and the client doesn't want to search because he thinks he's done a great search, and people start getting complicated.
Right, makes sense. Okay, so then let's move on to patents. So
Yeah.
that's, of course, not everybody needs a patent. It's a very small number of sellers who would really need a patent. But how do you actually go about protecting a product, and when should you actually require a patent for your product, and how do you
Yeah.
know if there is already a patent,
Yeah.
on the product?
That's there are, just like copyrights, there are two things that you should think of when you think of patents. Do I infringe a patent, and can I register a patent? So private label, when you think of it, it has risk of patent registration, patent infringement, because what do? Private labels, they search on Amazon and Jungle Scout and Helium 10. They search for great products, right? So first, so let's say they found this amazing bottle that I'm holding here, that has a special shape and that you can open and everything. So they found it. They see it selling very well, not a lot of competitors. They want to sell that product. and they label it and they call it Cupco. Okay, that's the brand. That's the brand of my bottle here. So let's say they found a great supplier. They're changing it. They're making it better. Great colors. And then they start selling. And then boom, turns out that the original designer of that bottle has registered a patent or a design patent. And what happens there? Then then you need to see if that's actually infringing. And if it's infringing, you need to go to the owner of the patent and see if you can come up with like a license agreement where you pay them for the patent they have. In some cases, it's there are sad stories where people got had like 5,000 units, and then they got stuck with that patent complaint, and the complaint didn't want to hear anything and didn't want to get into any license, and they needed to find another way to sell those units. So they usually go to other countries where there's no patent, and there are other solutions, but it's hard. So I always suggest, very, very important, to do at least your own patent search. If you're an advanced seller, then you can probably afford a real patent search for your product. If you're a new seller, sometimes again these expenses, it's hard to keep up. So at least do your own search. And when doing a patent search isn't easy, but let's start with a basic search of the original owner. So if, for example, I know that I'm going to start selling a bottle that's super similar to the Camelback bottle. Do you know the Camelback brand?
Yeah.
So let's say that I want to sell a bottle that looks exactly like theirs, right? So I'm going to go on Google Patent, or I'm going to go on regular Google. There's a Google Patent, like Google just for searching patent. So I'm going to go there and write Camelback patents and see what kind of patents they have. So if I go on Google search and write Camelback, I'm going to see a lot of patents that they have, and I'm going to review and see if I have that particular bottle that I want to sell. And if it's there, then I know there's a patent and there's a problem, and I really need to change it completely so that I won't be infringing. So my advice is, if you're not going to do a professional search, at least do a search that focuses on the original designer or original seller of the product you're going to sell. Okay. Mm-hmm. It's not always easy, by the way, to find the first one, but with the research, you take the top 3 or top 5 on Amazon, eventually you get to the original one, and very often they've registered patents. So best way not to infringe patents is, first of all, to do a search, and second, to change the product. Okay, so even if there's a patent on that bottle, okay, if I changed it and I removed, I'm not sure if you can see, I removed the dots that you have here, and I changed this part, and then here it's rounded, more rounded, and I added more stripes, and the whole thing looks different, then at least I did not infringe the second type of patents, which is the design patents. Design patent protect the shape of a product. So a lot of products on Amazon are protected by design patents. People like this bottle, for example, is probably protected by design patent. They protected the shape, the external shape of the product. Right. So as I said, the more you change it, your risk goes down. Okay, yeah. So
how much do I need to change it? I mean, are there any guidelines? Like if I can change, 1 or 2 features, or up to, is there a number or percentage, or how different should it be from the original patented design?
It's a good question. So first of all, there's a difference if there's a utility patent and a design patent. A utility patent is more, it's more general, so it's sometimes hard to kind of bypass the utility patent, but the design patent is much easier to kind of circumvent. So if, for example, there's no real number, right? But if you have 6 changes that are significant, and not, not just the top of the, of the bottle, or just change 2 or 3 dots. If the whole thing looks different because you changed 6 things, and at the end the whole product looks different, then it's hard to remove you. The legal test is substantially similar. So if there's the design patent and you're selling something that's substantially similar, you're still infringing. But if it's, there are so many differences that it's not substantially similar, then you wouldn't be infringing. It's hard to tell, at the end, it's in the eyes of the judge, right? So for some Amazon representatives, those 2 bottles will look very similar and it's substantially similar. And for other representatives, it looks different. If I show you here, I'm not sure if I can, I have 2 of those bottles actually. Yeah. I haven't prepared that in advance, but just so you see. So, you can see the differences here, right, on the top. So is that substantially similar or not? If you look at it, the entire bottle looks similar. It's just the top. I don't think it's enough to go around that pattern. So you need more than that. Right. That's a general reply. But the more you change, not only the risk is lower, but also you'll probably be able to register your own patent. So goes back to your question. Who can register a patent? So a design patent that covers the shape, if you design something and it's new and you've designed it, not someone else, you haven't taken something from, someone else, then you can register a design patent. If it's a new shape, if you have a new microphone, if you've designed, I don't know, a new bottle or a new camera or a new pillow, then you can probably register it. So even if you didn't invent a wheel, like you took a product that already existed, but you changed 5 different things, and one of the feature is great, and this is what what sells, most likely you can get a design patent. It's not that expensive, and this, as I said earlier, it has a lot of value when you exit, when you sell your business, and in general, it's great because you can remove people copying your product.
Right, makes sense. Wow, that was a lot of information, Yael. So trademarks, copyrights, patents, we can go on for a whole day over here. So great. Yael, do you also want to tell us your, your own services, and how can people contact you, and what sort of services do you offer for Amazon sellers?
So we, as I said earlier, we do everything related to intellectual property. So we register trademarks and copyrights and patents and design patents and everything that's related. We also help with problems on Amazon. So if you're suspended for trademark patents, etc., but also all other, for variation, misuse, or ODR, or inauthentic, or anything. That's basically what we do, and we're very busy with.
Right. And what's the best way for people to contact you?
You can reach me on Facebook, or on our website, or my email. It's yael@e-cabilly.com.
Right. And we'll put the email address in the show notes as well, so that people can contact you. Well, Yael, thank you so much for your time today. It was a great conversation, a lot of learnings, and I hope we can meet soon once COVID ends and all of the conferences start.
Yeah, definitely. Thanks for having me. It was fun.
Yeah, thanks a lot. Take care. Bye.
Thank you.